Please be seated. This is the time set for argument in the matter of Trisha A. versus Department of Child Safety et al., our juvenile case number 17-0126. Each side will have 20 minutes within which to make their arguments this morning. We have read the briefs, including the supplemental briefing that was submitted pursuant to our order. We've been through the record. We've conferenced the case. So I think we're pretty familiar with certainly the issues and hopefully the underlying facts and procedural history. So please keep that in mind as you make your arguments here today. We're recording the proceedings for both by audio and video. The video will be available on YouTube in a matter of days after the argument's completed. But because we're recording it, we would appreciate it as you approach the podium, if you would identify yourself and your client for that recording. I forgot to mention that appellant may reserve some portion of your 20 minutes for rebuttal. It's up to you, however, to keep track of your time in that regard. With that, appellant may proceed.
Good morning. May it please the court, David Bell appearing for appellant Trisha A. And I do understand the court is familiar with the facts and history. I'll be brief. I don't expect to use 20 minutes. But just briefly, my client appeared or failed to appear at a pretrial conference in a termination action in the juvenile court. The court initially found that she had waived her rights and proceeded to take evidence and testimony and ultimately terminated her rights to her child. The trial counsel for appellant thereafter filed a motion to reconsider.
Okay, can I ask you a question? The hearing that your client did not appear for was a report and review hearing?
It was a pretrial conference. I may have misspoke. It was a termination pretrial conference.
All right.
And also, it was also scheduled as a report and review, I believe.
All right.
What's the difference between the two?
A report and review, the court would not be able to proceed to a termination because that portion is not set for the termination proceedings. So the report and reviews.
Is a review part of a dependency?
It is, which happens typically every 6 months or sooner when there's younger children. And it's generally at report and reviews if there has not been compliance by the parent at some point in the case that the court will change the case plan. That did happen in this case. The court changed the case plan quite a bit earlier on before the pretrial date in question in February of 2017. It was probably 7 months prior, I believe, the case plan had changed.
But after a severance petition has been filed, you still have report. This is my ignorance. You still have report and review.
You do, and the reason for that is the court, the pretrial or an initial severance hearing isn't really the hearing to gain additional information about the well-being of the children, and so the report and review requires a report from DCS for the court to review. To make sure that the child's needs or appropriate services are still in place, which is separate than a non-substantive pretrial hearing.
And then what would be the purpose of, by contrast, what's the purpose of a pretrial hearing in this case that was set like 7 months before the trial date?
The pretrial usually is the date where you see if the matter has been resolved, and if not, you set trial dates. That did occur in this case in the summer of 2016.
It was just after a mediation, I understand?
Yeah, the court set an additional pretrial for February of 2017, but also set trial dates for March of 2017.
But the purpose, I understand the purpose of a pretrial conference in this setting is mainly procedural. One, to determine, as you say, whether the case needs to proceed.
Correct.
But there's no, and to set, I suppose, further disclosure deadlines if appropriate. But there's no stated reason, or there's no purpose of a pretrial to resolve issues on the merits.
No, and unless the parent concedes at that time, which did not occur in this case.
Right. Okay.
So the court found initially no good cause. The trial court reversed that decision upon learning that mother had gone into a treatment facility. Then at a status conference shortly thereafter, the state advised the judge that mother stayed just 2 days in the treatment program and then left the facility. Because of that, it appears the judge reversed course again and found that good cause no longer existed. And I am here today letting the court know we believe that was error. You don't undo, once there's good cause, you can't undo that good cause by actions that happen after the fact.
Am I correct in thinking that the court's resolution of the finding of good cause in this setting was solely based upon whether mother had a legitimate excuse for not being there that day, as opposed to sort of the two prongs that Trisha A talks about, which is a good reason for not being there and some meritorious defense?
Yeah, you can see in the record there's not much as far as meritorious defense addressed at all, which is part of the reason I think the court is looking at this case. But given the fact that the court found good cause, the court has discretion to not proceed and take testimony. And so I believe the court was within its purview to not go to any second prong. If the court decides in its discretion that, this doesn't feel right to terminate a parent under these circumstances, then that was the court's decision. I believe it was appropriate.
So you're saying that the court in this case shouldn't have even gotten to whether a meritorious defense had been allowed? Well, are you, or are you saying?
The court could have.
Yeah.
Based on the laws currently stated that we understand, the court could have gone there, but the fact that the judge found good cause, he did not have authority to then undo that based on mom leaving treatment 2 days after the hearing.
As opposed to where she was on the day of
Correct.
the hearing.
And I know the state in its opposition or its motion to undo the set aside argued there was no meritorious defense and then opposed and urged that at the status conference as well. But I didn't see anything in the record where the judge actually made a ruling or finding in that regard.
And trial counsel for appellant didn't do much on that either from the record. So it was just, could the judge have used the meritorious standard initially? Probably. He didn't do so. And so I think at that point the good cause was found. The important distinction between the Brenda D case and even the Trisha A case is that both of those matters were trial dates where parents, arrived or didn't arrive or arrived late. And so the court addressed that. And the Brenda D case repeatedly talks about the failure to appear or to timely appear at an adjudication hearing. That is not a pretrial conference. And as the court alluded to initially, at least there's thought that a pretrial conference is merely a day to affirm discovery and reaffirm, in this case, the trial dates that were already set.
Well, the Rule 64 and actually several provisions in the rules that talk about these preliminary hearings appear to give the court not appear, does give the court discretion to not only find some form of waiver of legal rights, but also the ability to accelerate the final adjudication. And that's what appears to be happening from our perspective. Are you arguing that that rule should not be enforced in that regard, that if a parent fails to appear at a pretrial conference, a settlement conference, a report and review, permanency hearing, whatever those rules are in the panoply of severance rules, that the court should not be authorized to, that DCS should not be allowed to ask, and the court should not authorize accelerating the adjudication hearing? In other words, to convert that missed pretrial conference into an adjudication hearing that day and proceed to adjudication.
That is what I'm suggesting, that it's not an appropriate rule. It's based on our civil rules that have different standards of proof. The Riches case, which was a slip and fall case from 35 years ago, gave some instruction. The courts have since cited that case in juvenile matters, saying that while they're not completely analogous, we're going to go ahead and use that standard. And I think it's inappropriate, especially given even the Brenda D case. There seems to be a greater scrutiny. The appellate courts are putting on these termination matters. They involve fundamental rights that are much different than the rights of citizens in an injury case. And I did disclose last second, because I just found the case, another injury-related case that I'm telling the court doesn't apply, because I'm asking that we not use that meritorious standard at all. But if the court felt that it still has some application, that recent Wynn case talks about even with inexcusable neglect for a non-appearance, it may not be the right thing to proceed if the outcome is just not justifiable by the court.
So just to make sure I understand what your position is, I think I'm hearing you argue that the requirement of a meritorious defense, whatever that means, along with a viable excuse to constitute good cause, that should be limited to a parent's failure to appear at a scheduled final adjudication hearing, as opposed to one of these pretrial proceedings.
I am saying that, and maybe especially with the caveat, in this case we had trial dates already. So there were trial dates. The parent was advised, she knew that she had a trial date. Certainly she knew she had a pretrial conference also, but we had trial dates. What's the harm to the court or the state? And I referenced this terminology, which is offensive, that the practitioners in the juvenile court call these drive-by cases, where you just this trial was scheduled for 2 days, probably 6 hours worth of testimony and evidence, and instead it was all done in about 10 minutes. The entire hearing took, I believe, 26 minutes, 25 minutes, but the actual testimony, rather than the 13 or I think 11 witnesses that the state listed that they intended to call, they utilized one witness. Instead of all the evidence they were going to present, they presented 2 court reports, one of which was filed the day before this pretrial conference. So it shouldn't have been admissible, given that it was, defense hadn't even had a chance to probably look at it. That should have been raised at the lower court level, that the court shouldn't rely on a report that was turned in the day before the hearing, which is outside of the rules. Those reports should be in 15 days prior. Regardless, this court gets the sense that these are not adjudications on their merits. They're quick matters for the sake of judicial economy. The Attorney General's office has a big caseload. They don't want to take every case to trial. The courts are busy. When they can dispose of a case in 20 minutes rather than 2 days, they take that chance. And I think it's inappropriate. I did cite to several other appellate courts, which I don't like to do. I usually feel like it weakens my client's case if I have to look outside our state for law. But I felt that the cases were very much on point, addressing the merits and saying at a pretrial, there's no harm to the state or to the court. It is not a substantive hearing. It's a matter that, usually just takes minutes. You affirm trial dates. The client says next to nothing at those because it's not a day for evidence, which explains why trial counsel is at such a huge disadvantage when the judge says, okay, we're going to hear evidence despite no witnesses being here. Disclosure probably hasn't even been done in most of these cases. And prior to the Brenda D case, lawyers were hamstrung, feeling like they really couldn't even make arguments at all. In this case, I think we saw two questions from trial counsel.
In terms of applying the requirement for a meritorious defense, which is taken from the civil procedure common law.
Yeah.
In terms of applying that to a Rule 64 situation, isn't there also the anomaly that the evidence in a severance, the evidence is developing over time to culminate? I mean, the deadline for that evidence to have developed is the date of the adjudication.
Correct.
But say your client hadn't appeared for the September pretrial.
Which in fact she did not. The record showed she had I believe a criminal court matter that same date.
So that was 8 months before the date that the court eventually set for trial. And that's 8 months that she's entitled to work services to get to resolve the situation. So, I mean, doesn't that make it a different scenario from a Rule 66 scenario or a civil procedure Rule 60 scenario too?
It's just different completely because we can call this a civil case, but it is unlike any other civil case. And again, the burden of proof is different. Yeah, you can say mom cut a huge break. She had all these additional months to work on this.
Well, that's how the system works, though.
It does. And it just doesn't make logical sense that at the end of that, of giving parents all these opportunities, then we foreclose their actual day in court. And I say parents, if they haven't done what they need to do, they should lose on the merits at a real trial with real evidence presented and with the court actually hearing the full scope of the evidence rather than 10 minutes worth. And before they called it defaults, and the court has reminded us that waiver is a more appropriate term on these. But yeah, you're shut out because you didn't show up. And the saddest cases are the ones where legitimate good cause existed, but they say, well, you didn't show a meritorious defense because your trial lawyer at an initial severance or a pretrial hearing didn't present anything because he didn't know the evidence that the state was going to present because it wasn't set for trial. He didn't get to question the witnesses, the experts, because they don't testify because they weren't subpoenaed for the pretrial conference. So it's a case where parents that don't do what they need to do, they shouldn't be allowed to walk away from this saying, I lost because the court treated me unfairly and didn't let me have my day in court at a trial. If they lose, it should be, I just heard a mountain of evidence against me that proved the state's case.
So just hypothetically, if the court in this setting, your client does not appear for the pretrial conference report and review, the court says, well, I don't find your excuse to be persuasive, so there's no good cause. We have a date set for the severance trial in March. I'm going to consider that there's been some waiver of legal rights here, and how does the judge determine what that is and what extent that waiver?
Yeah, given the recent cases that mean something different than it did a few months ago. Now it would mean the parent can still fully contest everything. They still have all their rights until the evidence is actually taken, which is the reason why the state wants to rush the testimony, so they don't open it back up for the parent to fully contest.
So you read Brenda D as being very limited to those facts as Brenda D, where the parent is late to the hearing, as opposed to having missed the hearing.
Yeah, and the other thing is I read it as applying specifically to adjudications. And I don't know what the Brenda D court would have done had this been a pretrial. They use the word adjudication repeatedly. How would they respond if it was a pretrial where some of the other law says, well, if a parent shows up late to a pretrial, I guess the court halts the proceedings and just affirms the trial date. But in this case, again, the parent wasn't there. Good cause was found. And I will reserve my last 30 seconds if I need it.
All right.
Thank you.
Thank you, counsel.
Good morning. May it please the court, my name is Joanne Falgett and I'm representing the Department of Child Safety in this matter. I just wanted to clarify a few things to start with. The parent in this particular case had indeed missed many hearings and had indeed failed to participate over a period of 16 months from the time the dependency case was filed until the pretrial conference at which this event occurred. She had not been in contact with her attorney for 4 months. So when the court found that she failed to appear with no good cause, that was pretty eminently reasonable. And when the court decided, because it has discretion, it doesn't always have to go forward and accelerate the hearing and conduct the actual adjudication hearing at that time. And in fact, many times the courts don't. They say, great, mother failed to appear, and we're going to go ahead and, affirm our trial dates, and they do this thing, they call it preserving the failure to appear, where she's waived her rights for whatever they were worth at that hearing, and then they show up at the next hearing, and if she's still not there, they go and do the evidence.
What rights then have been waived? That's what I was having a conversation with counsel about.
After Brenda D, the basic rights that she has waived is her right to appear and participate in whatever hearing she is not at. Her attorney, she still has an appointed attorney. Her attorney still has the right to participate in the hearing, to present witnesses and evidence, to cross-examine witnesses, to even challenge the factual affidavit or allegations in the petition. If, however, the parent completely fails to appear under Brenda D, at the end of the hearing, whatever factual allegations have gone unchallenged are then deemed admitted. So in the case...
Oh, I'm sorry. I interrupted you.
No, please.
I wanted to go back to your comment about how, well, if the parent doesn't appear as scheduled at one of these pretrial conferences, it doesn't necessarily mean that while there may be some waiver as to that hearing, doesn't mean that the hearing is going to be converted into a final adjudication and accelerated. I'm curious about this because there's a government website which describes this proceeding as if a parent fails to appear, the DCS routinely asks the court to deem the parent's rights waived and to accelerate the final severance hearing. And then describes an initial severance hearing. If the parent doesn't appear, they will be defaulted and his or her rights terminated after brief testimony from the department. Attorneys often refer to this type of hearing as a drive-by. So that's a Maricopa County, maricopa.gov website listing. So I have
I'm not familiar with that particular website. I'll take your word for it.
I'm curious as to where that information comes from, number one. But this seems to suggest that although the rule talks about discretion, this descriptor says that the courts the DCS is asking, and the courts are acceding to that request, and they are routinely finding waiver and accelerating the final adjudication.
Well, I will, two responses to that, if you don't mind. First of all, none of that evidence is in the record before this court. Her attorney did not make any of these kinds of objections at the hearing, did try to establish that she had good cause for failing to appear, or at least cross-examined the case manager about that, but did not object to any of the stuff that is in the supplemental brief about the shortness of the hearings and the other procedural issues that they're now waiving. To the extent that I may also be allowed to go outside the record, I would say, yes, the Department of Child Safety is very concerned about the statutory objective that allows these rules and these statutes, which is to achieve permanency for children. And when you have a parent who fails to appear, particularly a parent who has failed to appear repeatedly and hasn't even participated in services, yes, the department is going to ask that the hearing be accelerated and they be allowed to present their evidence. These hearings...
But the court's finding in this case on a lack of good cause didn't reference mother's purported failure to avail of services or participate or communicate with their lawyer for 4 months, whatever, all those things you listed, did it?
I frankly don't have it memorized, but my understanding was that the court at the hearing was well aware of the fact that, and mentioned that mom had not been participating in service, heard evidence that mom had not been participating in any of the services. And at the end of the hearing did, or actually I guess before this hearing started, did in fact find that she had not demonstrated good cause. Now, the mother in her brief sets forth a list of things that constitute good cause, and had her attorney presented anything like that, the court likely would have found good cause and simply continued the hearing, or perhaps affirmed the trial dates and said everybody show up on the trial date, one of those two. But in this particular case, her attorney didn't present any argument or any reason. I mean, he didn't know where she was, basically. And, you know, he did try to cross-examine the case manager a little bit about where she might be or, you know, what could have happened, but he didn't offer anything substantive that the court could hang its hat on to find good cause for failure to appear. And in light of the circumstances of the case, went ahead and found that she did not have good cause. That finding, though, is always subject to a motion to set aside. And had mother, in the motion to set aside, actually demonstrated good cause and a meritorious defense, then the court would have vacated the findings and held the hearing. The problem that happened, she filed the motion to set aside and alleged excusable neglect, essentially, for her failure to appear, and within 4 hours after that, the juvenile court entered an order vacating the termination order. That shows you how willing they are to vacate these things. But the problem is it didn't follow its own procedures. It had not allowed the department an opportunity to respond. So the department objected to that, asked that it be allowed to file a response, and that the court reconsider that ruling after having heard from both parties. So the court did that.
Was that done after having additional information, specifically that she had left treatment 2 days later?
Yes, and also that she stated that she could not attend the hearing because she was at the treatment center at the time. The hearing was at approximately 10 o'clock in the morning. She didn't check into the treatment center until noon.
Isn't it true we don't know that conclusively, though?
Well, we don't. But again, she didn't
Where
demonstrate.
Where did that come from? The state's position that she checked in at 12 o'clock?
Well, they did conclusively demonstrate that she had checked in at, they got that information from the treatment center. But the mother claimed that, well, she had to go stand around and wait in line, and so she had been there longer. But I submit that regardless of the court's initial inclination to grant this based on, you know, a finding of excusable neglect, when presented with the actual facts, the court decided, no, this wasn't excusable neglect, and reasonably so. If you think about this, mother had declined over a period of 16 months to participate in treatment, and then she decided...
Before we get away from that point, so why should the court consider what happened after the date of the hearing? Because the question really is, why were you not here today?
Right.
Not, and then you did or failed to do X later. That day, that morning at 9 o'clock, she was not in court. The reasons why she was not, why should the court consider anything beyond that, if not at a full hearing?
Well, okay, two things on that. First of all, I do believe that the evidence that she left the treatment center a couple of days later goes to her good faith in asserting that she intended to actually complete the treatment this time, which was the basis for the excusable neglect. I mean, again, she had been for 16 months declining to participate in drug treatment and drug testing services, and on the day of the pretrial conference, when she has been told, if you're not there, you could be subject to having the hearing accelerated, waiving your rights, and losing your parental rights, she decides that day to go to the treatment center, doesn't contact her attorney, doesn't let anybody know that she's going there, and then checks out 2 days later. It almost seems like, and I think maybe the court reasonably concluded, I don't think the court was relying so much on the fact that she left the treatment to find no good cause, as the fact that she left the treatment might indicate that maybe really what happened was she missed the hearing and she thought, oh, I got to come up with a good reason, so I'll go over to the treatment center and check myself in, and hopefully that will be good enough.
Ms. Falga,
Certainly.
you might want to, after this hearing, you might actually want to go check the record, because that noon time that you seem to think is important, I think, is the timing of a subsequent email from the facility documenting that she was in the facility days earlier. Our sense of this record is that there's no conclusive proof as to what time exactly she was admitted to the facility.
Okay.
I'm curious about the other part of the burden that the case law seems to place on a parent in a Rule 64 context. Is there, first off, are you able to put your finger on any cases that discuss the issue of a meritorious defense obligation on the part of a parent who's been defaulted or waived pursuant to Rule 64 as opposed to Rule 66 in a final adjudication hearing?
Not off the top of my head, Your Honor, but I could research that and submit
Well, no, I
supplemental
would
if
think
you
that
like.
would have been in the briefs. I'm not sure there is any, and I was wondering whether you had found any.
I didn't specifically look for any because it seems to me that the two rules have the similar purpose, which is to expedite permanency for the children.
Well, they do, but they're in dissimilar situations, timing-wise. Okay, second question. Your briefs talk about that the burden of showing a meritorious defense is hardly a burden at all. Requires very little showing. What's the best case in the juvenile court situation, in a severance situation, that talks about what that burden is, either under 66 or 64?
Well, the best cases that I found that talk about the burden at all are the ones that we cited in the supplemental brief. So we can see. But the bottom line is, it doesn't have to be, there's no specific amount of evidence. It's going to depend on the evidence that was presented at the hearing. So the department has the burden to prove by clear and convincing evidence that severance grounds were met. And in some cases, they prove that by clear and convincing evidence, and in some cases, they probably prove it by overwhelming evidence that goes far beyond clear and convincing. And so the quantum of proof that a parent might need to show so that the juvenile court could conclude that it might have affected the outcome could vary from case to case.
Well, but, okay, in your brief, you suggest that it is as minimal as, in a civil context, the evidence that would be sufficient to defeat a motion for summary judgment.
Sure.
What's the case authority for that?
Well, the juvenile cases are civil cases, and again, they are analogous to these default proceedings. And so we are looking at what constitutes a meritorious defense in general. I mean, the cases have held that those general standards that apply in the civil cases apply here as well.
What about the fact that a final adjudication hearing is somewhat like a default in a regular civil case, in that if I file a complaint in a civil case and I'm alleging a tort, the issue is whether a tort has occurred, and it either has occurred or it hadn't occurred. And that's the same whether we go to trial the day after I file the complaint or we go to trial 6 months after I file the complaint. The evidence is what happened before. That's different, isn't it, in a Rule 64 context? In the context of a pretrial hearing like what happened here, the parent is continuing to have, the state grants the parent an opportunity to work the services and demonstrate that her parental rights should not be severed. So when we proceed directly to an adjudication in a Rule 64 context, the parent loses that time, doesn't she?
Well, sure, yes.
And so shouldn't that be reflected in the burden to show a meritorious defense? I mean, it seems like it's a different situation entirely.
Well, certainly the juvenile court has broad discretion to determine whether it believes that something is a meritorious defense or constitutes excusable neglect for failing to appear. And, you know, I submit that if the court makes such a finding and there is some evidence in the record to support it, that would most likely be upheld, I assume. But the issue here is that mother didn't even allege anything that rose to the level of excusable neglect or a meritorious defense, and therefore the juvenile court properly denied her motion to set aside.
Well, I'm sorry. My recollection is that although the court acted prematurely, the court did in fact implicitly find there was good cause shown on the basis of the parents stating she was in an inpatient facility at the time of the hearing. So the issue is not whether she showed good cause, because presumptively she did. I understand the state's position that it was a premature determination, and ultimately the court reversed that ruling. So it seems to me the issue is, was there a sufficient basis here for the court to undo that?
Well, two things on that. First, yes, I believe that there was, because, again, the court made its initial ruling without having heard argument from DCS about the merits of mother's argument. And then, second, I would submit that in simply procedurally undoing the premature vacating of the order, at that point then the court had the opportunity to either decide, yes, we have excusable neglect and a meritorious defense, and we're going to go ahead and go ahead and vacate completely the order that terminated her parental rights, or it could do as it did in this case and find that those things did not exist and therefore was going to, reinstate the order terminating her parental rights. So the court could have at that point gone, once it vacated the order to procedurally allow the Department of Child Safety to respond as it should have done, then it could have gone either way, depending on what it heard at the hearing and the evidence that it considered. The other thing that I would submit is that in mother's initial motion to set aside, she didn't set forth the correct standard for vacating the judgment. So when DCS submitted its response to the motion, its objection to the set aside, it explained she needs to show the excusable neglect, she needs to show a meritorious defense, she hasn't done either one of these things, therefore please, vacate that order setting aside the termination order. And once the court applied the correct standards and understood more fully the evidence, then it decided that no, in fact, she didn't have excusable neglect for failure to appear. So, and I think if you look at the context of this case, the court certainly had plenty of evidence in front of it to reach that conclusion. Again, she hadn't even spoken with her attorney for 4 months, he advised the court. She hadn't appeared at the hearing. She hadn't participated in services. And so rather than delaying permanency further for these children who've already been in care for 16 months, the court reasonably concluded, well, that's not excusable neglect under the circumstances. That's not a meritorious defense under the circumstances. And so we're going to, accept the fact that the department presented, even though the hearing was short, presented evidence that the court found to be clear and convincing on all 3 of the severance grounds: the substance abuse, the abandonment, and the time and care ground. So this is, and also found best interest. on the preponderance of the evidence standard that is required. So this is not a case where there was slim evidence or where the result, when you look at the case as a whole, seems somehow unfair or egregious. This is a case where, mother was warned that if she failed to appear at this hearing, she could have the hearing accelerated, could be waiving her rights, could have her rights terminated, and she, instead of showing up for that hearing, she chose to do something else that day. And granted, if in fact she checked herself into the rehab facility with the actual intent of, stopping using drugs, that's an admirable goal. But it does seem that when your parental rights to your children are at stake, one might perhaps show up at the hearing first and then go to the rehab center, perhaps telling the court, I'm leaving here and I'm going straight to the rehab center. So can we reschedule the next hearing because I'm probably going to be an inpatient? She could have at least called her attorney to let him know, and he could have offered that meritorious or that excusable neglect defense at the hearing. But none of that happened. And so under the circumstances of this case, the juvenile court's finding that mother simply did not establish excusable neglect or a meritorious defense should be upheld. Two more real quick things. Even criminal defendants who are perhaps even losing their right to freedom can waive their right to participate by failing to appear. And additionally,
Not pretrial, right?
well, at whatever adjudication hearing is scheduled, and this particular hearing.
But is there a rule that allows the court, to find a defendant guilty if he doesn't show up at a pretrial conference?
I see my time is up, but I would love to. No, Your Honor, there's not a rule that says that.
Is there any case that says that happens?
Not that I'm aware of, but they certainly can waive whatever rights at whatever hearing they failed to appear at. And in this case, the rights at the hearing that she failed to appear at include the potential that the termination adjudication hearing could be accelerated and the parties could go forward in her absence if she doesn't appear. Thank you.
Appellee counsel mentioned the term delaying permanency. Doesn't the state invite delay by seeking procedural shortcuts rather than having the trial that was set in this matter? We're 15 months down the road at this point, and I think they invited delay that did delay permanency. Our courts repeatedly remind us that they favor resolution on the merits, and that's what should have happened in this case. Thank you.
Thank you, counsel. We appreciate the briefing in the matter and argument here this morning. We'll take this under advisement and issue a written decision in due course. We're adjourned.